Welcome to this month's edition of Stevens Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
Hello and welcome to episode 17 of Stevens Squibs Monthly Family Law CLE. And with me are my two co-hosts, Karen Stevens and Gina Sapucki. Hello, guys.
Hello. Good morning. Happy New Year.
Happy New Year. And do we have some really fun news to announce?
You could say that.
Yes.
You could say that.
Instead of me saying it, why don't we have Tony Award-winning James Monroe Eaglehart make this announcement for us?
Karen, Eddie, this is James Monroe Eaglehart here, and I hear that you are starting a law firm. Come on, a law firm? Stevens and Stevens? This is so awesome. I can even hear the theme songs. Stevens and Stevens, they'll get your money back. I think it's awesome. Or maybe you're an entertainment lawyer. Stevens and Stevens, they'll get your contract right. Or even just cool lawyers who just like help people. Stevens and Stevens, they'll help you. I think it's awesome. I think it's totally worked. I think look, I don't even need credit. You take that song and do what you want with it. I'll just know, within my heart, I did it. But I just want to say, guys, I think it's awesome. I just want to say, do not throw away your shot. Enjoy this moment. Don't feel helpless. No, because when you help people, you will feel satisfied. It will never be just one last time with you guys. You guys will just keep on going. And I am telling you, Stevens and Stevens, Karen and Eddie, trust me. History has its eyes on you. And other people will see how great you are and tell your story. I just want to let you know that I'm here for you. I can't wait to meet you guys. You guys are awesome. Rock it out, Stevens and Stevens.
So thank you, James, for making that announcement and actually coming up with our theme song. It's amazing that a Tony Award actor of your caliber would do that for us. So we are honored, and you all know that we are huge theater geeks, most of us. And if you didn't know, James just is Billy Flynn now in Chicago. That was just announced this week. So it's another way to go see Broadway again. Billy Flynn, gonna go check that out. So Karen, I look forward to our new future. And Gina Sapucki, thank you for being our rising star and joining our team and joining us on this excellent adventure.
It's very exciting.
So we thought we would just make this little announcement to the people who pay for our CLE. You guys get to hear it first. Don't tell anyone.
It's supposed to be a tiny spoiler teaser, but instead we have a Broadway star singing. But nonetheless, we don't do anything small if you haven't figured that out yet. So
I like surprises. So without further ado, because we don't get CLE credit for that, let's get straight into the materials. And these are squibs from November 2021. Every case that came out, we have some interesting ones. Not a huge month. And we're doubling up on the squib board cert tip of the months. We're going to do 2 this month, 2 next month. That's just because the test is coming up and we want you to have tips from all 10 test passers from last year. So expect a great show. Starting off right with your materials. And of course, your materials are emailed to you on the 15th of every month in your email that tells you to go see the show. There is an attachment and you have written materials with all of these cases written out. These cases are also on our website, www.eddiestevens.com. And so if you don't have the written materials in front of you, you can just always access them on the website. Just go to the month that we're talking about. First case in the pile, we're talking about agreements. We have an interesting third DCA that talked, it's the Pardes, is that right? The Pardes case. And it dealt with a 33-year marriage. And it basically found that the party's non-marital home became a marital asset because they lived in it as their marital home, and they cited the Hooker case. The trial court cited the Hooker case. And this really talks about the donative intent. And the Hooker case is a great case. It's based on the trial court found that a card to his wife saying, "This is our house," that constituted donative intent to transform a non-marital asset into a marital asset. But really the case is about the trial court having great discretion when it comes to a factually intensive issue. And the appellate court says determining donative intent is a factually intensive issue. So it's not really a rule of law, but if the court finds something when it comes to these issues, that finding is going to be respected all the way up. And I think that's what these cases are telling us. It is a fact-intensive determination, and trial court has wide discretion. So that's the first case, agreements.
So we're going to hop over to alimony next. And our second case in the materials is the Harby case, number 2. Harby, if you're paying attention, is actually case 11 also, and it falls under some equitable distribution principles this month as well. I'm going to cover both of them, but I'm going to talk about the alimony part first, since that's the heading we're under. This was a 16-year marriage. It's a second district case out of Pasco County. Parties signed an MSA that pretty much resolved everything except former husband's claim for alimony, his claim for child support, and the equitable distribution of the parties' 2 dogs. So we're going to focus on the alimony stuff for a second. In the final judgment, the court found that former husband needed alimony and former wife had an ability to pay. But what the court did is it contemplated an increase in the alimony at a certain point in time following the entry of the order. So former husband was given a number of alimony, and then it said when he bought his new house, his alimony was going to go up because he needed more. And there wasn't a really good analysis or fact finding or going through the different factors of alimony as to why the court made this decision to increase it. So it is an error generally to have an automatic increase or decrease in alimony that's not connected to child support or something like that based on the facts and the living circumstances of parties. Can't do that. Judges can't do that. I know we do it in agreements sometimes, but that's a different kind of situation. Judges can't contemplate increases. So unless it's a big, huge asterisk, unless there's a thorough and detailed analysis of the extenuating circumstances why the court is making these findings. And unfortunately, this judge did not do that. There was just this, oh, he's buying a new house and it's going to go up. And that was not a detailed analysis enough. So it was remanded and sent back down to the court to make the proper findings and to have the reasons that are extenuating why there needed to be an increase in alimony. So that's the alimony principle in Harby. The equitable distribution part of Harby involved the parties' 2 dogs that had primarily been raised and living with the former wife up until the parties separated. And when they separated, former husband sort of took possession of the dogs. But former wife came into court and made an argument that one of the dogs was her emotional support animal. And both of the parties stipulated and agreed that the dogs should not be separated. So there was a very lengthy analysis and discussion in this case about the distribution of family pets in Florida. And there was a discussion about how in some states we can consider the emotional capacity and the emotional additives that these animals have for parties. And there's time sharing of pets in some states, but not here in Florida. They're still chattel, despite my bleeding dog mom heart. It is not anything that the court can address as far as who better serve the dogs. But nonetheless, under 61075, we have to divide the dogs. And since the parties agreed that they should not be separated, the judge ordered that the dog stayed with former husband, but there wasn't an analysis under the 61075 factors as to why he was making that finding. And that was the problem. Ultimately, the court did say that it was affirmed. There was no reversal or remanding, but they should have followed the factors to determine why the dogs were given to former husband versus former wife. And they actually dismissed former wife's claims that, oh, it was an emotional support animal and all this other stuff. Nonetheless. So ironically, the dogs hadn't lived with her for 4 years by the time it went to court. So I think her ESA argument was kind of ship sailing. So nonetheless, really great discussion about family pets if you want a good read under Harvey. The next alimony case this month is Watrell, which is number 3 in your materials, and also number 8. We have a couple of these double cases this month. Watrell talks about alimony issues and also attorney fee issues. So in this alimony principle here, the former wife had been a stay-at-home mom for some time. She was actually a licensed mental health counselor. Husband was a pretty successful personal injury attorney up in what county? Duval County up in Jacksonville. And the court awarded in the final judgment that the wife was entitled to $10,000 a month in permanent alimony, and did not impute any income to her, despite the fact that the former husband had a vocational assessor there who testified that the former wife could have been making about $35,000 a year in an entry-level position as a mental health professional. And the court did not take that into account. And there was no findings that she could actually contribute to some of her own support. So it was reversed, remanded back, and the court found that there was an error in the fact that they did not take into account what former wife could have contributed to her own living expenses if she worked. By the way, the two parties' children, the reason the wife was a stay-at-home mom is because their oldest child had some special needs, and that special needs child had already matured past the age of majority. So there was really no reason why the court found that she should still be staying at home as a mom. Now, also under Watrell is the attorney's fees issue, which is much briefer and much shorter. But former wife had requested $130,000 in attorney's fees at trial, and the court just halved it and gave her $65,000. No explanation why, no findings why, just cut in half and gave her 65. So this was also reversed and remanded because the court has to explain why it made a partial fee award and not a full award. And there needs to be specific findings. So that is Watrell, which is 3 and 8 in your materials. And if you're not sick of me yet, I have one more to discuss with you, which is the Dills versus Perez case, which is number 4. This one is only number 4. It does not duplicate anywhere else in your materials this month. This was a post-judgment modification of alimony case, and the parties had entered into a marital settlement agreement that gave former wife 48 months of durational alimony that was non-modifiable, 48 months. Former wife got herself remarried during the 48-month period, and former husband took her back to court and said, you don't get alimony anymore, you're remarried. And this was heard by a magistrate in Volusia County, which was ultimately the magistrate's report was ratified by a court order. And the findings that the magistrate made was that because the marital settlement agreement was silent on remarriage, that somehow her alimony terminated upon the remarriage. And of course, the court signed the order affirming the magistrate's findings. This was completely reversed and remanded. And what the appellate court, the 5th district, said is that non-modifiable is pretty darn clear. These folks said non-modifiable. And on the basis of signing that, regardless of the statute would give him the right to modify alimony and whatnot on her remarriage, because they contractually obligated themselves to non-modifiable alimony, the court should have upheld that. And there should have been no recommendation by the magistrate that her alimony should have terminated, because it was clear and unambiguous that the MSA would control over the statute. And that is Dills versus Perez. Now we're going to get into appeals.
I have seen a lot of agreements that don't limit that non-modifiability and just say it's, so I see a lot of those issues floating out there where people could probably catch them a lot longer than anticipated. So big practice tip, don't get into malpractice, and make sure you address that issue. Super important. Our appeals case, Charles v. Williams, it's kind of simple. Someone tried to appeal a final judgment from March 17th, 2016. The appellate court thought that that was a little untimely and dismissed the appeal. That's it for Charles v. Williams.
That takes us to number 7, Toth v. Miller. This is a case coming out of the 2nd district. This was a divorce action where there were many issues. And what the contention of this issue on appeal was, the former wife filed a motion for attorney's fees as a sanction for inequitable conduct against the former husband. What was made clear throughout this case is that neither party agreed on this inequitable conduct or the fact for it to be heard at trial. There was argument on it during trial about whether this motion should in fact be heard or not. And what the appellate court found in the material, or in reviewing the materials that were provided, is that it was suggested that the trial court said that we are going to reserve on this inequitable conduct matter because there needs to be a separate hearing to determine facts and of this nature. However, the trial court instead granted the former wife's motion for inequitable conduct as a sanction, so which is why the former husband appealed. And based on the facts of that, although the trial court has inherent authority to award inequitable conduct, because the former husband did not receive the proper opportunity to be heard during trial, that is the reason why the appellate court reversed this and to schedule a new hearing to determine that issue. And that takes us to case number 8.
So we already did case number 8 as a function of the alimony discussion. So we're going to hop up to 9.
And we are now talking about Marcellus v. Peterson, which is out of the 4th DCA. And this reflects one of these patterns of cases that we are now seeing pop up. So I would suggest that this is highly likely to be tested if you're thinking of the board cert exam. Deals with inequitable conduct attorney's fees. And in this case, $282,000 was awarded, but the trial court did not specify what portion of that $250,000 related to the inequitable conduct. So it was reversed back, and with specific instructions mandate for the trial court to just award fees based on what they found was actually met inequitable bad faith conduct and requires detailed findings of fact. Gina?
And number 10, we have gone over in the Whitaker v. Whitaker case. So that takes us, we also had done case number 11. So that takes us to income, case number 12 in your materials.
Well, this is a treat because we have Jonathan Mann, who is from the Bresky Law Firm, is the attorney who led this appeal for Mr. Damask, the appellant, and reversed the trial court. So we reached out to Mr. Mann at Bresky's office, and he was very happy to join me and help explain this case.
And the next case we are going to talk about is an income case. It is out of the 4th DCA, Damask v. Robachenko. I might have that wrong, but I have the attorney who argued the appeal with us, Jonathan Mann. Jonathan, are you with us today?
I am. Thanks for having me.
Thank you, Jonathan. And Jonathan is a board certified appellate attorney with the Bresky firm, and he had the help of a couple attorneys on this case, Robin Bresky, and there's one more in your firm.
Jennifer Delgado.
So congratulations on this case. And I reached out to you because I thought it was a really interesting imputation case. The husband, who it looks like you all represented, was tagged with over $500,000 of annual income, and that's when he was a commodity broker, and he lost his job, I guess, to reasons of his own doing, and the court just imputed the full amount of $500-something thousand for child support. And that's when I guess you didn't do the trial part. You guys just do the appeals, right?
That's right. We only handled the appeal on this case, and like you mentioned, the father had previously earned the sum that the magistrate eventually imputed to him, but he was terminated from his employment, and then he had difficulty in finding, subsequent employment in the industry that he had been in, which the Fourth DCA's opinion does a pretty good job of explaining the facts of the case and going through the father's attempts to find employment in the same industry, but his attempts were being unsuccessful. And then that left him in the position of not being able to earn a comparable income to that which he previously did, but still facing the magistrate's finding that he was voluntarily underemployed, I should say.
And did I understand the case right, that it doesn't really go into the details of how he lost his job, but it seemed like it was like to his own bad conduct, but it doesn't really teach us about that. But he wasn't fired and didn't lose his job involuntarily. I got the sense that he lost his job at the commodity broker for his own doings, which kind of leads you to think that already he's voluntarily underemployed just because, it was his act that caused him to lose his job.
Right.
But you need a little, but I guess you need a little more evidence than just losing your job and having a previous pretty big K1 or W2 on your tax return, because this was based on his previous year's tax return, and you guys were able to totally overcome that finding of fact.
That's right. At the hearing before the magistrate, the mother introduced a report that had been prepared by a vocational specialist that found, or that concluded, that the father could earn income at the level that he had previously earned before he was terminated from that employment. And the father objected to it, but on the basis of hearsay, because that vocational specialist was not present at the hearing. And so it was just the document. And by that point in time, both the parties were pro se, which is an interesting sort of factual detail. But the father smartly made the objection that, well, this vocational specialist isn't here to testify about the report.
And I guess the magistrate and then let it in, and the judge didn't do anything with the exceptions. So the case makes a big deal about the two-prong test, and I think we all know that there is a two-prong test to impute income, but everybody gets caught up if you lose your job, for cause. It's real easy just to stick your last W-2 wages with you. But the Fourth DCA said that that's not going to be the case. You need appropriate evidence, evidence that's admissible. So can you just talk a little bit about that second step?
Yes. So the second step of the test, and the Fourth DCA clearly took the opportunity to sort of explain the two-step test, and the opinion's helpful for that. But the second step of the test requires that the court has to determine whether the subsequent unemployment or underemployment resulted from the party's pursuit of his own interests, or through less than diligent and bona fide efforts to find employment paying income at a level equal to or better than that formerly received. And so part of that is that the party who is attempting to establish that the other party can earn a certain level of income needs to put on competent, substantial evidence of that income, and that being the availability of employment for the party who's voluntarily unemployed or underemployed. And so that's the factor that the Fourth DCA sort of the factor that the Fourth DCA found that there was not competent substantial evidence for the reasons we talked about, the vocational assessor's report being hearsay, The fourth DCA's opinion discusses a few other good cases on the subject. It's the Durand case, the Chipman case, both of which are helpful in sort of understanding this point of the law regarding imputation of income in these circumstances.
Well, I think this is going to be a very helpful case, and certainly give clear guidance, at least to us in the fourth, of the steps you have to take to impute income, and don't just rely on someone losing their job and having a high income in the past. You need the evidence, and apparently you need to have your vocational person there to overcome a hearsay objection to the report. But I can imagine two pro se people going at it, and I'm surprised they ordered a court reporter, to be honest with you.
That's right.
Well, I guess the magistrate was recorded. I don't know about the exceptions. So, Jonathan, any other tips about income imputation for us that you'd like to share?
I think we covered it. Like I mentioned, the 48 DCA's opinion is a good explanation of the law on the subject as it stands, and I think that's about all I have to say on the subject today.
And the citation is in case number 12 in your materials that you have, and the case is Damask v. Rybachenko. John, thank you for joining us, and tell Robin and all the folks at the Bresky firm we say hi, and thank you for contributing to our program.
I will. Thanks a lot, Eddie.
Big shout out to Jonathan for his help. Next case is Gillespie v. Mining, and we're still under income. This dealt with a lady who relocated to Missouri. There was a relocation case, and she didn't win that, but she stayed in Missouri, where she earned $57,000 a year. During a support hearing, the magistrate said, well, you know, the former wife voluntarily left, and here she was making 78. So I can impute 78,000 to the wife. And the husband, of course, you know, argued that at a hearing. I think he was pro se. And the court imputed $78,000 to her. Regardless of whether or not she was voluntarily underemployed, you know, if you're going to impute more than a person is making, you still have to have these findings that where they live, that's a prevailing wage, and, you know, tagging her with what she made at her previous location was not the appropriate standard. Modifications.
Case number 14 in your materials, that's the Essa v. Pepe Catalinas case. This is coming out of the 5th District. This is a post-judgment issue following a dissolution of marriage action between former husband and former wife, who were had a final judgment as of 2012, and they did have a minor child who, at the time of the final judgment, they did have a parenting plan that awarded the former husband primary time sharing, and the former wife, in fact, had supervised visits, and there was that step-up plan to allow her to obtain unsupervised visitation. Years later, about 2017, the former wife filed a petition to modify the parenting plan with the court. About a year later, there was an order that allowed her to obtain a social investigation between the former husband and the minor child. And there were, the facts show that there were allegations that were confirmed by mom from this social investigation. Almost 2 years later, following that social investigation order, the former wife filed a motion for a temporary parenting plan. Keyword temporary. The trial court heard this issue on the temporary parenting plan, and what they did is they granted the former wife's motion for a temporary parenting plan, awarding the former wife basically changing this time sharing arrangement between the parties. And this is what the former husband appealed to the appellate court. And after review, what the appellate court found is that the court cannot modify the party's final parenting plan that was entered in 2012 on a temporary basis, absent exigent or emergency circumstances. And when the trial court had the hearing on the motion for the temporary parenting plan, majority of the evidence focused on this 2018 social investigation report. And remember, the former wife filed this motion almost 2 years later and had a hearing later in that year. So we're talking between a 2.5 year time frame. And in that hearing, the former wife presented no current evidence of any emergency situation. All that was presented was what was put in the social investigative report of issues that have happened over 2 years ago. So for that reason, the appellate court reversed this order and said, absent this emergency finding, which was not present, and the former wife was using all this past evidence and history from this report, that does not allow the court to negate the final parenting plan and make a new one. So for that reason, it was reversed. That takes us to parenting.
So our next case this month under parenting is Reynolds versus Reynolds. And this is a first district case out of Walton County. It's really quite brief. And what the former wife had done at the very onset of this divorce is she, quote, absconded with the child. And there was a hearing on temporary time sharing and temporary custody determinations held by the court. And the court immediately made the finding that because the former wife had absconded with the party's child, and by the way, the former husband didn't see the child for almost 2 years by the time it came to court. The court made a finding that this was egregious, which obviously we could all agree is probably egregious, but then just made an immediate custody determination that the child should go to the former husband. There was no allowance of any evidence, any legal argument, or any presentation of a case whatsoever by the former wife. And because of that, it was reversed and remanded back to the lower court so that they could actually conduct a hearing and make a proper custody determination. Just making a finding that it was egregious what the former wife did and then not allow her to present her case was improper. And that is Reynolds.
Our final case of parenting, case number 16.
Wait. We can't let Reynolds go by without a Hamilton reference. There was a pamphlet, right?
There was a pamphlet, lots of pages.
Not known me president. No.
Oh, Mariah Reynolds. What are we going to do with her?
Sorry to interrupt, Gina.
That's okay.
Couldn't reason.
Case number 16, Pescod v. Irvin. This is a case coming out of the 2nd District. Very short. The former, this was an appeal of a ex parte temporary emergency order that basically did not allow the mother temporary any more time sharing. And what this case teaches us is that although Mr. Irvin did file an ex parte order limiting time sharing, he did not allege any actual emergency situation. All Mr. Irvin did was attach an unsworn report of a guardian ad litem, which was explaining all the reasons why time sharing should be suspended. And that on its own is not enough without an evidentiary hearing, because his motion solely relied on this report. So for that reason, this order was reversed and remanded. That takes us to procedure.
Our final case of the month is the Schmacher v. Schmacher case out of the 2nd DCA, case number 17 in the materials. Kind of an interesting jurisdictional case. The Schmachers filed for divorce way back in 2009 in another state. The divorce was dismissed, but it resulted in several judgments for like alimony and child support arrears. And the wife everybody moved to Florida, and the wife was collecting those judgments or attempting to collect them in Florida, filed for a new divorce in Florida. And the Florida judge got concerned about this The other case was in Maryland, got concerned about it, and just sua sponte dismissed it because of a lack of jurisdiction. So the appellate court took a look at the issues and for a couple of reasons reversed the trial court to the extent that it questioned personal jurisdiction of the parties. They only need personal jurisdiction over the filing party. In this case, the other party submitted themselves to the jurisdiction by responding and, specifically submitting themselves to the jurisdiction. As for subject matter, just takes a party to live 6 months in the state. That was no problem because one of the parties did. To the extent that the circuit court was concerned about ongoing litigation over the temporary support and arrearages judgments, those issues had no bearing on the court's jurisdiction to dissolve the party's marriage. So the order dismissing was reversed and the case was put back on. So that's the end of these cases. We have 2 board certification tips coming up from 2 of my favorite people, Julia Wida and Christy Mitchell will be sharing some good tips. We were going to give out our books at board certification for those people who ordered it. They have come in. We are not, because your subscription to the CLE this year was so cheap, we're not including a book with the subscription, but you're welcome to buy one if you want. All this stuff is free on our website, but it's kind of cool to have a book and it supports a really good cause. We said we were going to give them out at board cert. The world is changing very rapidly. We do not feel comfortable going there. So I will be paying the postage personally to ship these books to all of you that have ordered them. If you have not ordered one and you would like one, there's a link on my website to do that. Please, there's also check your email for this month's episode. There'll be instructions in that email how to order it if you want it, because now's your chance. And I have bought all the books myself. I'm paying for the postage myself. And this way we can raise hopefully a lot of money for the Center for Child Counseling so they can do great things. With that, I want to thank Jonathan Mann for his appearance and Julia Wida, Christy Mitchell. You guys are up with your board cert tips of the month. We will see everybody in a new filming from a new location in February. Peace out.
Stephen Squibbs presents this month's board certification tip.
All right, now we have our monthly section of our board certified tip of the month, and we have an exciting guest today. She is the president of the Palm Beach Bar Association and one of our most recently board certified family law attorneys. Julia Wida, welcome to our little CLE.
Thank you for having me, Eddie. I am so happy to do anything I can to help other people pass this exam.
It is a crazy exam, but very passable. I think it's hard, but I think a lot of people get scared because there's that stigma that it's too hard. But after you took it and you passed, do you think it's a fair test?
I think there are a lot of challenging components to this exam. For me, the most challenging is the time. There is a lot of time pressure on this exam. And I think in your preparation for taking the exam, you should try to time yourself and get used to the fact that this is really a test of how quickly you can get down all of the stuff you know. And if you are prepared for that, it'll make it feel less stressful as you're taking the exam. Many people have had to take this exam more than once, including me, and there is no shame in that. And for the young women with children, I want you to know that this is definitely doable. And if you approach it as a learning process, this is something that will only increase your practice and make you a better lawyer.
Julia, we've already interviewed like 6 or 7 folks that passed this year, and they have all said the same thing: time management. And some folks don't even have time to finish the multiple choice. They run out of time of essays. So it's really important to be able to get this stuff out on a paper. And just out of curiosity, when you wrote your answers, were they in a narrative form, or did you do something a little more casual, like just listing things? How do you approach writing your answers?
So I tried to stylistically write in a way that I thought that the exam reviewers would know that I understood the material. I am a good writer. They would get all of that. The problem I had is I would start that way, and then with the time crunch, by the end, it became more like bullet points. But I would add in some explanation, so it wasn't just bullet points. There was something else there, some substance with it. But that is how I started each of my essays, in an actual paragraph form. I was thinking about not only the content, but the style of it. I was really trying to do the best job I could.
And approaching the studying of this test, and they give you the core and the subcore, and it's really everything, right? Everything that they tell you to study is going to be tested. Would you agree with that?
Yes, I studied everything.
So how did you approach that?
Okay. So I had watched all of your case law updates and all of your interviews with the people who had taken the exam and passed. And one of the common things I heard was, go back to what you had done during law school and undergrad. And so in law school and undergrad, I tended to read things 2 to 3 times and really think them through. And I know in our professional lives, we don't have that kind of time, but I tried to incorporate that. So starting right after July 4th, I celebrated July 4th with my family. I have a 4-year-old daughter. We all celebrated together. And then I started to really focus on studying. And I started with, they'll tell you 2 years of the Florida Law Weeklies. I actually did 3 years. And I very actively read all of the cases. I was highlighting, I was writing notes in the margins. I was making note cards based on the things that I was learning. I actually have like a shoebox full of note cards while I was doing that. And what I was finding as I was reading those cases is common things were coming up. There were common issues, common patterns. So I had a notebook that I would keep beside me, and I would write down all of these things. So sometimes it was a conflict in the DCAs. Sometimes it was an issue that was recurring. And I just kept this beside me. By the end of all of my studying, I had about 45 of these common issues, patterns, themes, whatever they were. And Eddie, I believe that most of these things were tested on the exam in some way, whether it was short answer, whether it was multiple choice, or somehow on the essay. A lot of this stuff was picked up on. And then I also kind of did the same thing with all of the statutes and the rules. I very actively read, I highlighted, I had note cards. I would keep in my notebook, if I noticed that there was a statute that changed or a rule that changed, I would write that down in my notebook, and I'd have this list of everything I knew that had changed in the last year. And then I would memorize all of that and just keep reading, keep reading, keep reading. I did not outline every topic. I know most people will tell you to do that. I did not do that. And then as we got to the cert review course, I started to focus more and more on the red books. So I found the red books, there were certain things that weren't in depth enough. So this time around, I added a new material. I added this yellow book. And if there was an area that I wasn't totally sure about, I would read the entire section on it. And I think reading it and hearing it in a different way, and some of this is a little more in depth than what the red books have from the cert review course, I think that helped. It's just digesting it to the best of your ability. However you do that for yourself, I personally think this helped me. I also used this book. I thought this had a little bit more depth than the cert review materials. I think they're all excellent. And for me, all of them helped me to get a really good understanding. And then Maria Gonzalez and Abigail Beebe had said something about once you've finished studying a certain area, try to write down everything you've learned about that area so it's crystal clear. And I did that for all the core topics. So I might not have outlined per se, but I had these little summaries that toward the end, the last few days before the exam, those summaries and a few of my note cards, that was all I was using. And then I was kind of like speaking it out with myself and expanding on it and just like quizzing myself. So I fully got it.
I agree that reading the Florida Law Weeklies, as you know, is a great component of learning and staying on top of the law. It's not the only thing I do, but it's the primary source, and just having exposure to it every week, because I read it every week, at least the family cases. You're right, those trends become very apparent. Would you read the Florida Law? Did you subscribe to the Florida Law Weeklies and read them weekly, or?
Yeah, so I used 18, 19, and then I got the draft bound copy of 20. That's what I did, and I used all of them, and you can see everything is very tabbed up. And what we actually did is I was lucky enough to have two study partners, Cash Eaton and Grant Gisondo, and we used some of these cases. I would make copies of just the fact pattern, and then I would put in, the trial court ruled X, and then we would make our own short answers, and we get on Zoom and we time ourselves, because the time is really an issue. We time ourselves and we try to get through it, and then we talk it through a little. And I think that was really helpful. That was something I had never done in the past. So I do think that having study partners, if you really like them, know them, trust them, they all pull their own weight, then maybe that's something for you.
So starting the summer before, I guess it's like 8 or 9 months of a study regimen, how many hours total do you think you put into it the year you passed?
So during this exam, I went online and bought something that looks like this. It's a calendar. It's 1 page per month. And I would also keep this in my study area, and I would log all my hours. I was at around 400 hours of studying. I know that sounds ridiculous, but Grant went all in.
Grant says he was at 500. So he's the furthest amount that I've gotten. And most people say it's somewhere between 1 and 400 hours. And it's to have these initials, it's significant. And I served, when I served on the board, the committee, and it's a bunch of humans that are not we're not professional test writers. We're just family lawyers that make up this exam. And serving on the committee, I probably learned more about family law just because it was such an intense experience. Mm-hmm. So if anyone is looking for a committee to serve on and you're board certified, the most rewarding and challenging committee I've ever served on is the board cert committee. But as they're humans, they sometimes don't get it right. And did you ever take a look at your previous test?
Yes, and I appealed in the past. I didn't go all the way up like Jacqueline and Megan did, but I did appeal and just kind of got a response that was, you didn't pass. So
did you find a benefit in reading the test answers?
I did. And I could see what they were testing. And I could see that in the time allotted, I was struggling to get down everything they were covering. I mean, those model answers, they're very, very in depth. And the time that's allotted on the exam, it is very hard to accomplish that.
Well, and reading those answers actually helped you the next year?
Yes. This whole process, I mean, I would say anybody who's going to take it and you're afraid of failing, don't be afraid to fail. I mean, you are honestly going to learn so much. You're going to become a better lawyer. Your practice is going to be better. I mean, there's so many reasons to just do it despite the fear of failure. And there's a lot of, fear-based stuff that happens at the Tips and Nibbles course and all of that. Just block that out. Jeff Weissman had talked to a group of us, a small group of us, and just kind of reiterated how important it is to stay positive. And I took that to heart. And I basically did everything I could to keep the people around me and myself as positive as possible about this. So whether that means you have friends who keep your spirits high and make you laugh, be with those people, keep them in your life while you study. If that means that you enjoy yoga and meditating because it keeps you calm and keeps you positive and keeps your outlook positive, then do that. If there are affirmations or power posing, whatever you have to do, you have to stay positive, because the reality is there is a psychological component to this exam. It is almost like mental warfare. We are all good lawyers. We all work hard. Everybody's studying. The percentage rate is ridiculous. And so you're going in knowing this is a battle and not everyone's going to pass it. So stay positive. I really think that was another key piece of why I passed this year, because I did make that a priority after I spoke with Jeff Weissman.
That's a great tip. And I think, we have a self-fulfilling prophecy at times, and there's so many people that do kind of fear-based mongering about this test that really prohibits people from even signing up to take it. Mm-hmm. And like you said, when I sat and actually studied for it, it made me a much better attorney. Whether I passed the test or not, just going through that knowledge and, forcing yourself to do that immersive dive into family law, I think that's, no matter what, it's a win situation. So, yes. So there's the positivity right there. You're going to be a better lawyer, whether you have these initials at the end of your name or not.
And there's something personal that comes with this experience too. If you have to take it more than once and you persevere, you come out of it not only feeling like it's a professional success, but like personally, I feel very proud to have survived all of this and just kept pushing through. You almost feel unstoppable. And I think that is in and of itself the win, right?
Well, overcoming trauma can make you very resilient and almost give you superpowers. So I'm glad you have taken the reins, Julia, and I see what you're doing with everything in Palm Beach and the vision you have, especially, for working moms that are lawyers. And, you're an example that it can be done and done with grace.
Thank you.
So congratulations on being one of the ones that passed. We're all trying to get this passage rate up, and the purpose of these little chats are to take away the mystique of the test and to, let everybody know, yeah, it's a tough test, but, if I can pass it, certainly, all you have to do is figure out how you learn the material and put in the effort. And it might take more than one time. And if you have that expectation, you're not going to get crushed, but as family law attorneys, we get crushed all the time. So
we can do it.
But this is kind of personal. I get that. So Julia, any last tips you want to give our listeners? And also thank you for subscribing to our CLE series. You have been one of our biggest supporters, and we really appreciate you very much.
I do think the case law updates are very helpful. The more you listen to other people talk about the cases and you hear it from a different angle, so I really think this is very, very helpful for people who want to take the exam.
Well, Julia, thank you for your positive messages and your time today. And hopefully these words will encourage and help other people with this obstacle.
Yes.
Julia, have a great day.
Thank you so much for having me.
Stephen Squibbs presents this month's board certification tip.
Ladies and gentlemen, welcome to our board cert tip of the month segment. And this month we have a great guest, Christy L. Mitchell, who has been practicing law since 2009. And she's one of the folks that just passed this past year. And she runs her own law firm, CLM Law, out of Orlando. Christy, nice to see you, and thanks for joining us on our show.
Thank you so much for that wonderful introduction, and thanks for having me.
Well, we're on a mission here to help people pass the board exam, board cert, and I can't think of a better way than talk to people who just passed it. And fortunately, we have such a great bar where pretty much everybody we've asked to participate has done that. So we're giving out a lot of tips to test takers. So speaking of some tips, this is they say family law board cert's the hardest test you could probably take in your life, right?
It was hard.
How did you approach the whole test taking process?
I did everything I could think of, really. The pandemic hit, right? And then I didn't have to drive anywhere. I didn't have to drive to the office and drive back. So now I had more free time. So I actually, starting in about September, got up early at like 5 o'clock every morning and studied for an hour and a half every morning before my kids got up, Monday through Friday. That was the first thing that I did. And part of the studying, I actually brought my little study things with me. At the Nibbles and Tidbits, which you get invited to if you're allowed to sit for the exam, as one person recommended ordering and reading all of the Florida family law cases published by Florida Law Weekly. They come out in this little green binder book. And so I ordered those for the last 2 years. And I read every single case in there that had to deal with family. They have a bunch of dependency cases. I just skipped right over those. I made flashcards. I have a giant shoebox full of flashcards. That's just how I retain information. So basically everything I could.
So I kind of want to dig in and figure out the materials. The green books are great. And there's a little trick. You can order the softbound one early in January to get it a couple weeks ahead. Any other resources that you looked at or were in your toolbox?
Yeah, the red books from the board cert review that they have every year. I had those for the last 2 years. That's where I started my outline. And I'll say it was probably in January or February. And I think the test was actually in March, but January or February, where I realized that not all the topics on the test are actually covered in the red books, right? So I was kind of scrambling last minute when I figured that out, but luckily it wasn't too much information that wasn't covered in either of the last 2 red books. So,
and the red books kind of change every year. I think I have 15 sets of them since I've been going, and some years are better than others. How did you go about learning? Did you feel like you needed to memorize statutes and all of the elements in all these statutes, like relocation, alimony, unequal ED, that kind of stuff?
I did. How
did you get that stuck in your head?
I used mnemonics and made up just crazy. I mean, some of these factors have like 20 plus factors, you know, I just had crazy mnemonics made up. I asked other people if they had any. They didn't. I Googled. I think some of them are probably inappropriate, or I'd share them with everyone, but
whatever it takes to be able to retain all this information. And not only do you have to retain it, but the real test is not just, what you know, but how you use what you know and applying it in the essay questions and some very tricky true, false, multiple choice. This test gets criticism that it's just too hard and the passage rate is too low. Now that you've passed it, do you think that this is a fair test for board certification?
I'm biased, right? It sets me apart. So it's really difficult. I'll tell you that much. And I think that there's a lot of people who know a lot of the broad strokes, and really the board cert test, I think, is especially with the multiple choice and the short answer, like true, false, and take a position, those tend to focus more on the nitty gritty. I mean, I remember one multiple choice question and the difference in the answer was one single word.
Christy, did you keep track of how many hours you put in studying for this exam?
Not specifically, but definitely over 150, somewhere between 150 and 200 for sure.
And COVID being a really interesting year to take the test because the way the test was administered was different, and we're just in a different time where, you know, you probably have a lot more time available to study than you would otherwise.
Right. Yeah.
So that was probably helpful.
It was somewhat helpful, but it caused a lot of anxiety that this was the first time that the test was going to be administered online. And then, you know, you weren't allowed to have any interference or interaction. You couldn't have your phone there.
I heard the proctoring was very anxiety ridden.
Yeah, you're videotaped the whole time, you know.
So I believe this year they're returning to live testing, so these folks won't have that issue. But whatever life throws at you, you got to deal with it.
Right. Yeah.
Do you have any other tips that you would like to bestow upon our listeners who were in your position a year or more ago, thinking or getting ready to take this exam?
Ethics opinions. You know, when I sat for the test, I was thinking ethics was going to be multiple choice or one of the short answers. And we had an essay.
Yeah, they pretty much give you one essay and say there's 10 ethical issues, find 7 of them, I think is a passing score, or at least that's what it used to be. Did you think the ethics question was difficult, or did you, how did you take that?
I did think it was a little bit difficult because I didn't know any of the ethics rules, right? I know like the general principles of like, don't be an unethical attorney, but specific rules, you know, like with the family law substance, I memorized the statute. I could cite to the statute and list factors and all that stuff. So it helps build your confidence, which is why I committed to memory all those factors. But with ethics, I wasn't expecting to have to write a long essay, so I didn't commit any of the actual rules to memory. So a lot of my essay answer was just winging it. You know, it's like, oh, that doesn't sound right, but I don't really know the rule that says why. Let me tell you why I think it's unethical.
And I think the ethics question is either like a pass or fail essay question as opposed to the other ones that get weighted in part of your score. So
really?
you either issue spot all the ethics issues. At least we treated it differently when I was the chair of the board cert committee. And if you spotted enough issues, you passed that question. And I think if you didn't get the ethics question the next year, all you had to do was just take that. I could be wrong because it's been over a decade, but just mainly issue spotting, conflicts you got to know. Don't call yourself board certified if you're not, or a specialist if you're not. There were some advertising issues, a lot of conflict issues though. And
mine was sleeping with clients.
That's
like, when are you allowed to sleep with clients and when are you not?
Well, if the relationship had started before,
right.
But the fact that I know that just means I've written this test way too many times.
Right.
Christy, any other words you'd like to impart on our viewers or thirsty for this knowledge?
No, just best of luck to you all. It is a very difficult exam, so best of luck.
Well, Christy, I know your time is important, and I thank you so much for sharing it with us today, and thank you for your tips.
Thanks so much. Have a good one.
Thank you for joining us for this month's edition of Stephen Squibb's Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information. Thank you for joining us for this month's edition of Stephen Squibb's Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.